Is it better to settle your case or go ahead to trial and take what's behind door number 2? You want to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. That was the exact question I just got from someone who left a comment on one of my videos. Is it better to settle your case or is it better to go to trial? The answer is, it depends. Now, that's a famous answer for many attorneys. You want to know why? Because there are hundreds of factors to consider for each of those opportunities. And I say that they are opportunities. I'll tell you right now, when you settle a case, or at least if you are offered a significant settlement, and now your attorney tells you, listen, the value of your case is worth what they are offering, or what they are offering is clearly in excess or what your case is valued at. You then have to make a decision, because the decision is, if you settle your case, you are done, you are finished. This is the maximum amount of money that you'll be able to receive as full and fair compensation for your injuries. And if you agree to that, that's it. You can never come back. That is the final amount that you can actually receive, and you are done. No more money as a form of compensation for all of your injuries. If, however, you say, you know what? I'm a gambling man. I'm a gambling person. I believe that the jury is going to believe me. I believe that this jury is going to give me significantly more money as a form of compensation for all of my injuries and harms and disabilities and my future problems that I'm going to have and the need for surgery. And guess what? It's going to be far in excess of what's being offered right now. Is that true? Can you predict the future? Do you have a crystal ball? Are you able to tell what a jury who has not yet been picked, what a jury is going to do? 6 members in New York, 6 members of the community whom you have never met before, to sit and listen to all the testimony, to watch and listen to the evidence, to hear the attorney's arguments, and then to ultimately come to the conclusion that yes, let's say in a medical malpractice case, your doctor was careless. And yes, his carelessness was a cause of your injury. And yes, your injuries are significant and permanent. And yes, you have various damages for all the pain and the suffering that you endured from the time of the wrongdoing up until the time of trial. And yes, believe it or not, your doctors have confirmed that you are going to have suffering and pain into the future, not just for the next few years, but for the foreseeable future throughout the rest of your entire life. And your life, you are projected to live another 25 years. So, you believe in your mind that a jury is going to take all that into account and give you substantially more money than what's currently being offered right now. What do? Do you take what's behind door number 1, which is a guaranteed settlement, right here, right now, and you're done with it? Or do you take what's behind door number 2, where you don't know what's going to happen? Your attorney doesn't know what's going to happen. The defense lawyer doesn't know what's going to happen. You run the risk that if you go to trial, a jury could come back and throw your case out. And you're saying, that's impossible, I have a great case. Well, you may believe that to be true, but a jury may not. A jury may not like you. A jury may not like your medical experts. A jury may not believe your medical experts. And now they may turn around and say, I'm sorry, we don't believe the doctor did anything wrong. In which case you're out of luck and you get 0. On the other hand, a jury could come back and say, yes, your doctor was careless and your doctor's carelessness caused you harm. But we don't believe that your harm and injury is significant. So we're only going to give you as compensation a small amount of money. And you're saying that's impossible. Well, it's not impossible, because a jury is entitled and can do and is authorized to do anything they feel is appropriate. And if they feel that your injuries are not significant or disabling or warrant significant compensation, you are not going to get the true value of your injuries. Now, on the other hand, the jury could come back and feel that your doctor was careless, his carelessness caused you harm and injury, and that your injuries are very substantial to the point that they far exceed anything you could have possibly imagined. The jury gives you $50 million. And you and your attorney originally thought that maybe your case was worth $1 million, $2 million at the best, at the top. And your attorney has told you that the appellate courts, where your case is pending, that the maximum value for your type of injury is worth, let's say, $1.5 million, $1.5 million. And you say, let's go for it. And a jury comes back with an incredible decision giving you $50 million, $25 million for past pain and suffering, and $25 million for future pain and suffering. And you are thrilled, you are so excited, you are on top of the world. Guess what? The first thing that's going to happen is that the defense lawyer is going to ask the judge to throw your case out, claiming that the injuries and the evidence and the testimony are not consistent with the amount of money that the jury gave you. And because of that, they're going to ask to throw the verdict out. No matter what decision occurs, somebody's going to appeal, and in all likelihood, it's going to be the defense. And they're going to argue that the verdict in your case is inconsistent with the testimony and the evidence. And there is a possibility that when your case goes to the appellate court, that they could agree and throw the entire verdict out. There is the possibility that they could disagree with that verdict and say, you know what, we're going to send your case back and now retry it all over again because we think that there were legal errors made during the course of trial. And that is a possibility. So there are many options that can occur during the course of the appellate process now when your verdict is being reviewed. So getting back to the question, is it better to settle or is it better to go to trial? The answer is, it depends. And there are hundreds and hundreds of factors to consider. And the only way that you can make an educated decision about which option to choose, which one is best for you, is to have a detailed discussion with your attorney about the various factors and your options and your risk and your tolerance for risk. All of those are important to consider when making that decision. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I suggest you do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.